parties in this case were the children of the late Margaret Wilcox, who died in 2016 at the age of 90. She had 3 children. On one side of this battle was Edward McCarthy, and on the other side were his brother Dennis and sister Lesley. This is another case that has claimed a family relationship and resulted in a great deal of bitterness between Edward and his siblings. Edward claimed that his late mother's home in Wales, which was in her name, had either been held for him under a deed of trust, which she signed in 1998, or that he was entitled to it under her will of October 2014. His sister Lesley was opposed to Edward getting the house. Her case was that the deed was not valid as her mother didn't understand the document, or that Edward put her under duress to sign it. Lesley and Dennis also claimed that the October 2014 will was invalid as it was signed by their mother with undue influence by Edward. With 4 wills and a deed of trust involved in this case that included allegations of duress and undue influence, the judge had his work cut out to decide which of these legal documents would prevail. At the heart of the case was their mother's ex-local authority property, which she bought for £16,500, but is currently worth around £160,000. Was the deed of trust giving Edward the property valid? And if it wasn't, then which will was valid? The one of October 2014 giving him the property, or the earlier will of January of the same year giving all 3 children the property? Find out when case history continues.
Is your family being ripped apart by an inheritance dispute? Are you about to squander your inheritance on legal fees? Wait! Why not try mediation instead? It's a great way to resolve inheritance disputes. You get a result that works for you, and you rebuild family relationships. Plus, you save thousands of pounds on legal fees. Best of all, it only takes a day, so you save months and years of litigation. Mediation saves money, saves time, and heals family rifts. No one loses, and everyone's a winner. Go to remyayela.com/inheritance-disputes to get started today. Online mediation is available.
The 3 siblings grew up with their parents in Newport in Wales. After their father died, Mrs. Wilcox remarried in the mid-1980s. She moved in with her new husband to a 3-bedroom property which they rented from the local authority. That property is what forms the basis of this claim. In November 1997, the local authority offered the property to Mrs. Wilcox, who was by then living alone in the property, for sale. The property was offered at a purchase price of £37,500, but with a substantial discount of £20,625. There was correspondence between Mr. Baldwin, a partner at the law firm of Baldwin Townsend, and Mrs. Wilcox. She asked him to put a hold on the purchase of the property as money was needed from her son's property sale, referring to a property Edward was in the process of selling. She informed Mr. Baldwin that it would be a cash purchase. Correspondence between them continued. She later told Mr. Baldwin that there would be no mortgage and that Edward was providing the money, so she would have to wait till he had completed the sale of his property. Edward completed the sale of his property in February 1999. In March, Mrs. Wilcox went to see Mr. Baldwin, the solicitor. She signed the documents for the purchase of the property. At the same time, she also signed a declaration of trust prepared by Mr. Baldwin. This document stated that Mrs. Wilcox was holding the property in trust for her son Edward. This deed, signed by Mrs. Wilcox, confirmed that the purchase price of the property was £16,875 and that purchase money was provided by Edward, and that the property was being transferred to Mrs. Wilcox merely as a trustee for him. The purchase of the property was completed before the end of March. The property was then registered at Land Registry in the name of Mrs. Wilcox. Despite Mr. Baldwin writing to Edward about it, no restriction was placed on the register to protect Edward's interest. Mrs. Wilcox continued to live in the property for some 16 years after the deed was signed. By January 2014, her doctor suspected she had Alzheimer's disease as she became increasingly forgetful and at times confused. The first will was signed by Mrs. Wilcox in September 1999. By that will, she left the property to Edward, and other than a music centre left to her grandson, the rest of the estate was left equally between her children, her grandson, and her granddaughter. The second will was signed in January 2004. By that will, the property was left as to 70% to Edward and 15% each to his brother and sister. The rest of the estate was divided equally between her children and grandson. The third will was signed on January 3rd, 2014, again prepared by Mr. Baldwin. In that will, the whole property was no longer left to Edward. Instead, the will stated that the whole estate should be divided equally between her 3 children. The final will was signed on the 1st of October 2014. This time, the will was not prepared by Mr. Baldwin. Instead, it was prepared by Edward. The circumstances surrounding the will were that Edward was staying with his mother around that time. According to him, on that day, he was having tea with his mother, his best friend Wayne, and the wife of his best friend at his mother's home. Whilst they were having tea, his mother told them that the property would be left to him. Quick-thinking Edward asked his mother if she would sign a will to that effect, and she replied yes. He whipped out a computer and printer. Taking the will of January 2014 as a template, he prepared a will for her to sign, giving him the property and leaving the rest of it unchanged. Wayne and his wife Karen signed as witnesses to the signature of Mrs. Wilcox. Lesley's allegation was that Edward had coerced their mother into signing the deed of trust, but she had no direct evidence. Instead, she relied on a number of circumstances to show that it was unlikely that her mother understood or willingly signed the deed, even though she had accepted that her mother was not stupid and that she had been excited about owning her own home for the first time. She alleged that once her mother had been convinced by Edward that her mother had no choice but to buy her home because the alternative was homelessness. She also said her mother's eyesight was poor and she would not wear her glasses, insinuating that she might not have known what she was signing. She claimed that Edward had taken some money from their mother, which was why their mother had changed her will in January 2014. But this was all circumstantial evidence. Edward, on the other hand, claimed that it was his mother who had raised the subject of buying the property. His mother wanted to buy the property because the local authority was going to repossess it because there was a single person living in a 3-bedroomed house. Edward said they had an agreement that she would leave him the property if he paid for the purchase. Mr. Baldwin, the solicitor, also gave evidence. He said that even though he could no longer recall the exact events, he would have made sure that Mrs. Wilcox knew what she was doing and would not have allowed any pressure to be put on her. Regarding the deed of trust, the judge came to the conclusion that it was Mrs. Wilcox who was dealing with Mr. Baldwin all through the process. She responded appropriately to his inquiries over this time and sometimes even chased him for progress. This did indicate that she was aware of what she was doing. In addition, the judge said, given the substantial discount on the purchase price, it wasn't surprising that Mrs. Wilcox wanted to buy the property. But she could not have bought the property without Edward providing the money. Given all of that, it wasn't surprising that Mrs. Wilcox should want her son, who had provided her with the funds for the purchase, to be entitled to the property. She believed she had a moral obligation to leave the property to Edward. This is consistent with the earlier wills. Taking all this into account, the judge came to the conclusion that Mrs. Wilcox did understand the deed and signed it willingly. Accordingly, Edward McCarthy was entitled to have the property transferred into his name. Given the decision on the deed of trust, it was no longer necessary for the judge to deal with the wills, but he decided to do so anyway. Lesley alleged that Edward had procured their mother's signature on the final will made in October 2014 through undue influence on her. That was the will that gave the property to Edward and the rest of the estate to the 3 children. The concerns regarding this will are that by then Mrs. Wilcox was in her late 80s with a possible Alzheimer's diagnosis. In addition, all her previous wills had been signed at Mr. Baldwin's office, but not this one. Finally, the witnesses were Edward's best friend and his wife. However, the judge said, given the history of the dealings with the property, the provision in that will regarding the property was not surprising. The judge came to the conclusion that the will was not procured by undue influence. So the net result was that no matter which way you looked at it, the property would end up going to Edward. In this case, it does appear that justice was done. The main lesson from this case, which Edward learned the hard way, is always to insert a land registry restriction on the property to ensure that your interest is recognized and protected. This is really important for people who provide the funds for the purchase of a property, but for some reason the legal title is not put in their name. The deed of trust in this case was an important first step to take, but you should go further and include a land registry restriction. Another lesson to learn from this case relates to the October 2014 will. That was the last will. It's not the best move to prepare a will for yourself when you're the main beneficiary. Even worse, you shouldn't have your best friend and his wife as your witnesses. All these things immediately raise a cloud of suspicion, which can make it much more difficult for a beneficiary to prove the will is valid. Under these circumstances, you would have an uphill task trying to convince a judge that a will prepared by you for your 80-something-year-old mother who possibly has Alzheimer's, witnessed by your best friend and his wife, should be allowed to stand. Faced with Edward's situation, the best solution is to get a professional to make the will after confirming that, of course, the testator had mental capacity. And you should definitely have independent witnesses, probably the solicitor or professional who made the will, and also, if it's possible, get the testator's doctor to be one of the witnesses. That's the golden rule in these kinds of cases. Don't forget to subscribe to my channel, Family Wealth TV, for future episodes of Case History.